Observatory, and that was in March this year. And the title of the presentation was Remote Hearings and Making Them Fair, Accessible and Humane. And it is important, I think, when we think about how far we've come since last March, when the lockdown first was announced. I thought, for my own part back then, 12 months ago, that appearing anywhere by Skype was quite avant-garde and seemed quite snazzy. And I can't believe, really, 12 months on, how much I now take for granted things that I didn't know back then. And so whilst we, from time to time, like to pat ourselves on the back about how much progress we've made, we do also, don't we, need to bear in mind that it is ultimately to ensure that the litigants and the parties feel that their hearings are fair, accessible and humane, and that there is a dignity to the court proceedings, despite the technical innovations that we have all got to grips with. I also remind myself from time to time how tiring it can be for professionals and also for litigants to participate in a remote hearing, a video hearing, seeing 8, 9, 10 parties in care proceedings on a 2D image with lots of pictures over the screen can be tiring, and that is something to take into account. That sound and video quality, it can be variable. I know this week I've had a 3-day final hearing with a mother who ended up in person because her legal aid had been revoked, and there was no, the appeal was unsuccessful. And there were several occasions where her device wouldn't link to the internet, where she couldn't get a good signal. She borrowed somebody else's device. Her sound quality wasn't good. At one point, she had to be phoned through for the latter part of the proceedings. And it was tiring. It was quite frustrating and upsetting for her as well. And it did take quite a considerable amount of work to ensure that the proceedings were fair and that she felt that she was properly participating, even though she was doing so remotely. So it can be difficult. There are advantages. I found seeing children has been more straightforward via remote means, and that includes cases involving secure accommodation applications. On those hearings, previously there used to be a risk assessment to see if a child could be taken, often at some considerable distance from the secure unit to the court, and all of the difficulties and problems that could be caused with that set of arrangements. Whereas now it is very much more straightforward, and I've had much more access from children or with children in those circumstances, and I think those hearings have been the better for it. It's also been quite nice from time to time where a young mum is in a mother and baby foster placement and appears from that placement via video hearing to be able to see the mother with the baby. Whereas previously they would have had to leave the baby at home or in the foster home, come to court without the child, and then go back. And it's been very nice and quite disarming on occasions to see how some of the mums are engaging with their babies during the course of the hearings when they appear, not throughout the hearing, but when they produce the baby on their knee and play with them and so forth. So that's been very nice, but there have been, as I say, downsides and disadvantages. And the question of vulnerable, particularly in family work, not exclusively by any means, but the question of vulnerable clients, vulnerable parties, and ensuring that they are included is something to be borne very much in mind, and how to handle vulnerable parties. I'm mindful as well that there is a broad spread of attendees at this hearing, from very senior members of the bar and bench to those who are much younger and newer to the profession. I don't want to be teaching my granny to suck eggs, nor do I want to pitch this at a level that is unhelpful to the perhaps more junior members. So forgive me if I attempt to strike the right balance, but the question of vulnerability and litigants who have particular needs is still covered by Practice Direction 3AA, and notwithstanding, as I say, all of our perfectly laudable efforts and proper efforts to strive ahead with as much technology and get to grips with these issues, the question of vulnerable parties still needs to be seen as a priority, and ensure that their proper participation is secured. So far as the Nuffield Family Justice Observatory is concerned, they made notes, they made reference to these issues, and if this is an area of concern for you, then this document would be well worth searching for, finding, and considering. It deals with technical improvements, it deals with issues to do with interpreters, the vulnerable parties, those who have litigation friends, and the need for breakout rooms for counsel and legal advisors to have proper opportunities to take instructions and give advice. The opportunity to have virtual ushers, for example, to assist parties in navigating the proceedings, support with intermediaries, advocates, and additional support for litigants in person to ensure that they can participate fairly. It deals with issues to do with staff, having IT skills, necessary IT skills, and the effective running of remote hearings in practice. And it is well worth a look, well worth consideration. And it also has practical, the seminar in March had practical aspects to consider, particularly with parties feeling isolated or helpless, with life-changing decisions being made when they're not physically in a courtroom, and they may feel particularly detached or isolated from those proceedings, bearing in mind digital poverty, which is often overlooked by those who are more enthusiastic for the IT arrangements, and it can't be assumed that those thousands of vulnerable people in the family justice system are necessarily going to be able to engage in the way that others can. That is worth consideration, particularly looking at the question of vulnerability and ensuring that proper steps and measures are taken to ensure fair, appropriate, and open, transparent participation. So far as stories are concerned, I'm not sure what embarrassing stories you're all going to come up with. I can think of a few that come to mind. I had one case recently where I was dealing with a secure accommodation hearing, and one of the parties was the mother, and she didn't look at the screen at all because she was knitting. She was knitting almost throughout the hearing, didn't seem to be taking very much notice until I asked her what she was knitting. I thought, I'm going to have to deal with this and try and engage with her and get her to look at me, because she wasn't looking at me at all. So I asked her what she was knitting, and she excitedly showed me what she was knitting. So I told her that her skills were so much more impressive than my feeble efforts, and that helped. And then she got involved and got there was some engagement there, but that was initially an obstacle that she really wasn't seeming to take any notice at all. There was another hearing where I think the hearing was perhaps a little bit early for one party who attended in her pajamas, and again trying to make her feel comfortable, and before I could stop myself, I told her she looked very comfy, and I wish that I felt as comfortable as she looked. Again, she seemed to overcome the initial embarrassment, and she was able to participate in the hearing perfectly well. And lastly, again, it was one of the mother and baby unit cases, mother and baby foster placement unit cases rather, not a unit, where mum was there with the baby and showed me her little boy, who was very bonny, on her knee, playing with him nicely. And we made some observations about it was nice for the solicitor for the child to be able to see her client in full colour in the hearing in that way. And he was fine, he was playing nicely. And then all of a sudden, a few minutes later, all I could see was these little feet wiggling in his baby grow. And I said to mum, I said, oh, what's happened with the baby? I can see little feet kicking. She just looked at me and said, I'm changing his bum. so I suggested that perhaps the child solicitor didn't want to see all of her clients, and perhaps she could just move him to one side to maintain his dignity for future years, given that the proceedings were being recorded. So not so much embarrassing, but funny things do happen, as well as more difficult aspects. And as I say, as well as the potential pitfalls, there are advantages for these for remote hearings and the technology that's been in place since last March. So far as case law is concerned, there is an increasing body of jurisprudence regarding remote hearings. I know a number of you will already be well familiar with these. But there's a case of Re A in 2020, EWCA Civ 583, Re B, same issue, 2020 EWCA Civ 584, and another Re A, 2020 EWHC 1233. And there are various sources of guidance from the Family Division and practice direction updates and guidance as to how to ensure that proceedings take place fairly, and in particular how to deal with and assist vulnerable parties and those who act in person, and guidance as to how there can be proper access to hearings through remote means. Lastly, in terms of the future and what may happen in the future, to a degree, it isn't possible to say with great certainty at this stage, but as far as the family jurisdiction is concerned, I've recently received a message, it's called a recovery message from the President of the Family Division, indicating that at the beginning of the pandemic, he asked Lord Justice Baker to lead a judicial recovery group for the family court, which has been working to plan for the return to more normal working and ensure best practice and current challenges have been captured for consideration when looking at potential long-term changes. And as COVID restrictions are relaxed and a move towards more face-to-face hearings will begin, having regard to safety considerations, that group is now being asked to focus their attention on how we might achieve the most efficient return to court over the coming months, including implementing the best practices learned from remote working. So it seems likely that there's going to be a combination of return to face-to-face hearings, which will be, I'm sure, welcomed by the vast majority, but also some form of remote working is likely to be required, it seems, for the foreseeable future. And I would have thought interim hearings in particular, further case management hearings and shorter hearings are likely to continue by remote hearing. And there have been some advantages in being able to have fixed hearing times, 9:30, 10:30, 11:30 and so forth, fixed appointment times almost, rather than all matters being listed at 10:30 in the usual way when matters were in court and listed in that manner. So the aim is to get the balance right, and there is a period of review. So again, when looking at the future, worth bearing in mind that there is a review ongoing as far as the family division is concerned. I think that is about 10 to 15 minutes in relation to those four areas, but of course I'll be happy to help or contribute to the question and answer session in due course.
Thank you very much, Christine. So I'll go next. I'm Barry Cotter, and I'm a designated civil judge and have been for 11 years over 2 different regions. That means that I'm in charge of civil work in was in Devon and Cornwall, now in Bristol, Somerset and Gloucester. So the title of our presentation is Remote Hearings Demystified. So first of all, a few things from behind the scenes. Quite a few people have asked, why is it that we suddenly changed to BT Meet Me in civil hearings when we used to have other forms of telephone hearing? Why is that so popular? The simple answer to that is it's administratively easier for the court service. What the judges get is they simply get a crib sheet like that with the numbers on of the parties. And there's no clerk ringing. We're doing the ringing and we're doing the recording. So obviously it's far easier for staff than if you imagine the opposite position whereby all these calls were coming into a court centre, had to be received and then farmed off to the judge. CVP. CVP is HMCTS's sponsored product. It wasn't ready to be rolled out in April 2020. It was rolled out, I think, about a year, possibly even longer than that, before they intended to roll it out. And secondly, it's not the end state product. I don't have much experience of the next step. Judge John Livesey, who is speaking to you, of course, has more experience than me, but it's not the end step. It's an interim step to the idea of HMCTS's own product, which will replicate as near as can be a courtroom experience. It's fair to say, and I don't think that I'm saying anything terribly controversial here, that quite a few judges still prefer Teams. And there's nothing wrong, there's no guidance to us that says you can't use Teams, we can. HMCTS would prefer us to use CVP, it's their product, but they are happy if we continue to use Teams, and many judges too do. As for Zoom, that is not supported by HMCTS, and our judicial laptops won't allow us to use it. So that's the end, unless, as is happening in some cases in the business and property courts, both in my court, it's happened to me, it's happened to other judges and elsewhere, the parties have decided they want to use Zoom, and they'll provide a laptop and say, this is what we want to use, this is our method, and we will record it. And there has to be a protocol for recording it. Now, there's nothing to stop it. It's not illegal for me to do that. I just simply don't have any option to do it unless you give me a laptop. And that really tends to only be in the higher value cases. Right, some tips and pitfalls. Firstly, in relation to BT Meet Me, by definition, for most of you, at least one side will be represented. And for myself, and I think most of the judges that I work with in the civil arena, we'd say use CVP or Teams if you can, rather than BT Meet Me. Keep the telephone hearings to the most simple types of hearing you can. Secondly, and this is a plea, if you do have a BT Meet Me, try and use a landline. Of course, that's a new word now. I mean, we used to use the word telephone about 4 or 5 years ago. We don't use telephone anymore. It's now mobile or landline. But mobiles are a nightmare if the signal goes, because I have to then go through the rigmarole of dialing you back, getting you back in, all that sort of stuff. And there is a tendency for people to use interim hearings in a way that they don't use other hearings. So before and after, I've had calls from cafes and roving rooms and stations. And frankly, I would say that that's really not good enough. They're difficult hearings to conduct, and you should treat them as such. Another thing about BT Meet Me is there's no easy option for us to run on into a second hearing. So say your hearing's between 10 and 11, and I've got another BT Meet Me at 11. If you run on, you might think, well, there's no difficulty, but there is, because everybody else in the second hearing is then wondering where on earth the judge is and ringing the court and saying he's not phoned me up yet. So we have to stick to our time slot. I'll come back to that in a second. And another tip, if the judge has not told you it's being recorded, do prompt the judge, because I'm afraid I've had quite a few hearings where when it's come to an appeal, we found that the judges forgot to press *8 and *1, which he or she has to do, and there's no record. It's a very dangerous thing, leaving the IT in the hands of the judges, but that's the world that we're entering. Okay, turning on to CVP and Teams, can I give you, if I may, 5 tips about that? First is you need more than one screen for CVP or Teams hearings of any complexity. You simply can't run your practice, I think, efficiently if you're dealing with just one screen. Second, length of hearings. As I've just said, in the shorter hearings, it's difficult to run over with the telephone. It's also difficult to run over with any form of remote hearing using CVP and Teams. And because disproportionately problems with IT affect the shorter hearings, so in other words, if it takes us 10 minutes to get off the ground in our 30-minute hearing, we're in trouble. We might be able to absorb it in a day, but we can't. You've got to be particularly cautious about the time estimates. So if you get a time estimate for an hour for a hearing that you really think only takes 30 minutes, it's not because I'm expecting you to go on for 45 minutes. It's because we're playing on the side of caution. In the longer hearings, then your time estimates should please factor in the problems that are likely to be experienced, and it's going to be longer. Now, people have different estimates. You'll hear judges will say in civil hearings, well, I add on a third. There's no precise science to this, but I think you can work on the following basis. Firstly, some things will go wrong with a remote hearing or a hybrid hearing. They just will. Now, there can be a nature of things. Even just the 3-day one I've had ran smoothly, but at one stage, the expert had to go and get a different computer because he had a signal problem. And it takes longer. Taking instructions is a more complex feature of trials now. So the expert in this particular case, I won't tell you which one, doesn't matter, obviously went off script, seriously went off script. And I've got to let both counsel then take instructions about that. And it's not easy. We don't have the break room facilities. So that's going to take longer. Struggling with documentation as well. Witnesses, everybody. That can mean that the trial will take longer. And that leads me into another tip. Please bear in mind that our hardware probably isn't as good as yours. So I've had a lovely trial in which the solicitor has made a terrific effort and provided me not only with the hard bundle, but all of the documentation for the 4-week criminal trial that preceded my civil trial and all the photographs. Well, my laptop's just having none of it. It will, after a while, say, yeah, I'm prepared to download that, but I'm going to think about it. And if you try and switch and download that bundle, then, hey, I'm not interested. And it's difficult for me because everyone else's laptop's working. It's rather embarrassing, but that's just what I've got. It's extremely difficult. So please bear that in mind if you're in a big trial in relation to documentation. And that comes on to my next tip. If you've got remote hearings, please consider a hard copy core bundle. It doesn't have to be very big, but it's a tremendous advantage to have a hard copy core bundle. Because if you're switching between screens and everything else, it's much easier if you've just got those essential documents in hard copy. The next tip is your cross-examination needs more planning than it ever did before. Of course, some people just used raw talent and never bothered with planning. But for those of us who were pedestrian and did, it's an even more difficult exercise now. And one point I've touched on is it's very difficult to say to the witness, now, if you can keep your finger in your witness statements, I'm now going to take you to bundle B to show you how you've lied like a gas meter. It's very, very difficult to logistically get those things off the ground. So bear that in mind. It's just not so simple when you're thinking about how you're going to eviscerate a particular witness in cross-examination, that the logistics don't trip you up. And that comes back to perhaps thinking about core bundles. Also, you're going to have to work out how you communicate with your solicitor, your client, and or your expert whilst your cross-examination is ongoing, or indeed at other stages of the case. Yes, we're going to have breaks. Yes, I'm going to recognise that when an expert goes off beam, you're going to have time. Of course, I recognise that. And we have to have breaks because screens are difficult to use. But as for the open dialogue, the little yellow stickies that you used to get handed to you from behind, if you're in a remote hearing, or even it's a hybrid matter, you've got to work out a route of communication. That doesn't mean that we're stopping every 10 minutes. The next point is that it is, as Christine said, tiring. And certainly in the civil arena, quite a lot of practitioners, and this is unlike the position in family and crime and tribunals, are not in court every week. Okay, they're not. So a trial comes along a bit like a boa constrictor's sort of diet. Once every month, something very big will do, and that's it, and I'll digest that for a while. But in relation to that, you don't then get just the sheer impact of doing these back to back like the judiciary do, and it's tiring, and we get tired. Our eyes begin to struggle if day after day you're doing these, and you've got to bear that in mind. So in terms of the options of just extending the court day by an extra hour, then you might not get the friendly reception that you previously got to that suggestion, because someone just says, well, I'm afraid I'm tired. I've been sitting behind and staring at computer screen since 8 o'clock this morning, and I've had enough. So please take the normal court hours that you knew as a likely maximum. And in fact, many judges will now restrict the court day to a little bit of a shorter day, because they can not envisage just day after day of full hour sitting. We're on Zoom, we're all showing you our backgrounds, but please, if you're on Teams, do blur your background. A point Christine made about vulnerable witnesses. Could I make a plug for the Civil Justice Council's report on vulnerability in the civil courts? It touches upon that. And there are certainly issues that need to be considered in relation to how you handle a case if you have a vulnerable client or the other party has a vulnerable witness or is a vulnerable party. Turning to the future, and a few questions that have been raised about that. A personal view, but as a management judge, can I say one that certainly I'm highly likely to implement for my region, certainly in the near future, is that the default position will be that interim hearings in civil matters will be remote. Currently, CPR PD 23, paragraph 6.2, all ingrained in, no doubt, your hearts. But that says that telephone hearings should be the norm if the hearing's no more than 1 hour in interim hearings. Well, I think that'll be scrapped. And we'll get something much more flexible, but also much more ambitious. It mightn't go so far as all interim hearings being by default remote, but I think that 2 hours at least, and I would suspect there's a good chance it will be in civil hearings, the default position is that they're all remote. Currently, we have the rules that say if all parties are unrepresented, it shouldn't be remote, and if it's more than 4 parties, shouldn't be remote. Well, the court's been dealing with litigants in person in remote hearings now, and I don't think we're quite as frightened as either of those prospects as we were. So I think that will be the default position for interims. As for trials, far more complicated. When will trials be remote in the brave new world, and when will they be attended? I don't think it will be as simple as flicking a switch and we all go back to attended hearings for everything. I think there'll be much more careful scrutiny of it. And I think in every case, and this is a personal view, more careful consideration of whether there should be hybrid hearings. As for the view as to where the line should be taken, you've got various judicial pronouncements on it from the higher judiciary. It's still, as Mr. Justice Warby, as he then was, now Lord Justice Warby, said in a case called Cotter last year, it's still the golden standard that we have the assessing of the reliability of witnesses in attended hearings. But that doesn't mean you don't depart from it. And certainly there is a respectable view that flows from what he was then Mr. Justice Leggett, said in Guestman, which quite a few of you I hope will be familiar with, that in certainly commercial cases and some chancery cases, you should really be looking at the documents rather than the witness recollection in any event. So I can see that in hearings going forward, final hearings going forward, there will be the question of whether they should be attended. It's still going to be there. It's not going to be flicking the switch back, and hybrid hearings are going to be something that's going to have to be considered in every hearing. But can I give you just a short indication of where I think that line may be drawn? It's a personal view. Senior judiciary may disagree with it. And I think that for attended hearings in future, the default position will be that in 5 sets of cases, it remains attended and fully attended. That's cases that concern dishonesty, cases of lengthy trials where the lost time will just roll and roll and roll. Cases which require increased liaison between advocates and parties or between advocates. It's just difficult to manage it, and you can see that. And it's a bit like an elephant. I can not easily describe them, but you'll know one when you see one. And fourthly, cases that involve litigants in person who are unhappy with the technology and say they are. And fifthly, cases of complexity that involve litigants in person, not if they're not complex. I think all of those will remain attended almost by default. But I think hybrid hearings are something that we're going to have to consider in every case. Right, well, that's my short presentation. I'm not going to share any embarrassing stories with you at present. I might do later on. We'll see how brave I am. The only thing I would say is that the senior judiciary will give us lots of guidance. I just hope somebody at some stage comes up with a dog protocol, because as regards dogs, for interim hearings, as far as I'm concerned, the most frustrating point is people being interrupted by the dog, but also I'm a serial offender myself. So that's my point. Can I hand the baton over now to Stephen?
Hi, good evening, everybody. I sit on the Midland Circuit in crime in Nottingham and Lincoln. One of the benefits of Zoom hearings rather than anything else is you can see who the participants are. So if I see the numbers of participants falling during what I've got to say, I might well turn the microphone and the camera off and leave as well. In crime, up until the first lockdown, just over a year ago, virtual hearings were a rarity. Apart from the occasional link for counsel who were elsewhere in the country to attend to help out, we very rarely used them. Lockdown changed that overnight. The position now, over a year on, is that the presumption has shifted entirely away from all hearings being in person, unless there's a good reason for people to join virtually, to exactly the opposite. All hearings should be remote or virtual, unless there's a compelling reason for a party attending court. And in crime, that's applied now for almost a year to all admin hearings. So pleas, mentions, sentences and applications. We've tried to deal as far as we can with things all virtually. As time's gone on, that's extended to some cases involving evidence being called and contested in court. We've dealt with hospital orders where the psychiatrists have joined with the defendant from hospital. We've dealt with applications to vary orders where the parties need to be heard and say what they want to about whether an order should be put in place or removed. And on many of those cases, we've called evidence over the link, and either the defendant has been over the link and been cross-examined that way, or sometimes the defendant's been in court and parties have attended virtually and cross-examined them in that way. The difficulty in going from very few virtual hearings to nearly all virtual hearings hasn't so much been professional reluctance to get involved with technology. Surprisingly, everybody's been more than willing to try and do what needs to be done to keep things moving. It's more getting technology that's been fit for purpose, which has hampered us in crime. By way of an example, at the very start of lockdown back in March last year, we were told that we would have to do what we could by telephone hearings rather than anything else, because the kit simply didn't exist, a more interactive hearing with people from various different locations. It'll come as no surprise to anybody who's been in the criminal courts that the telephone technology we had at that stage looked like it had been purchased shortly after the collapse of the Soviet Empire. None of it worked particularly well. None of it connected to anybody of any use, and it routinely chopped people out and meant that hearings became almost worthless. We then moved to Skype, which was slightly better in that we could see the people we couldn't hear and talk to, or we could at least see their names as we tried in vain to get them to link in remotely. The position for people who weren't on bail but were in custody was even more complicated when we started. It involved having an incredibly complex lash-up of various laptops all looking at each other and filming the image on one, transmitting to another, so that everybody could hopefully see and hear the defendant in custody, and he or she could hear and see everybody else. And if anybody's ever done the puzzle with the fox, the hen and the bag of grain trying to get across a river, you'll know the difficulties that were involved with that. There was a very interesting and worthy piece of work from elsewhere in the country from judges who'd worked out a way to use 3 or 4 laptops in a specially set up way, simply so that you could see everybody. It plainly wasn't fit for purpose, but it was what there was. On other occasions, we've had people, solicitors joining over Skype or a television link from elsewhere with their clients who've been elsewhere, and the only way of contacting them has been for the solicitor to contact them on FaceTime on their own mobile telephone and then hold their own phone up to the screen so that everybody can see at least part of somebody's ear when they're talking to them. Things have moved on. We're now on CVP, the Common Video Platform, which isn't perfect, but it's a huge step forward. All of the courts have a designated license and a link. People are given the link and they can paste it into their browser if they've got the technology they need, and they can join at the same time as everybody else, and everybody's on the same format, and it seems to work a good deal better. There have been a number of advantages and disadvantages with moving towards virtual hearings. The main advantage is that we've been able to keep working. We've been able to reduce the backlog that otherwise would have been monumental to something that's merely staggering at the moment, simply because we've been in nearly every day doing as many short hearings as we can do. It has the advantage that the advocates don't need to come all the way to court. It also has the chance that we've been able to get hold of people whose cases they are, which is always a better way of doing things because they know the most about it, and rather than having somebody standing at the last minute and do their best, we've actually found it far easier to get hold of the people who know more about a case. There are obviously disadvantages, and some of these are disadvantages that overlap across all of the jurisdictions. The first disadvantage is that we've experienced in the early days a real lack of dignity and solemnity in the courts. People joining from different locations, from the garden, from the pub, from inside vans, didn't really lend itself to what we were trying to achieve. There's been a real difficulty in people on bail, defendants on bail, simply having the technology to join in. The idea that everybody now has a laptop or a smartphone capable of accessing the system just isn't true. And for many of the people we deal with on a day-to-day basis in crime, they're a long way away from having the technology to do it. So that's been a continual difficulty in trying to progress cases with defendants on bail. Another disadvantage is the lack of public access to hearings. The principle of open justice requires that anybody who wants to see a proceeding that's going on in court has a right to do so. We've been severely limited in that, in allowing people to join via CVP. We of course have let the press in. We've tried to let interested parties in who have a stake in it. We've also allowed, as time's gone on, people to come into court and sit in a socially distanced way to see what's going on. But that's been a real difficulty in terms of the public seeing what we do and seeing how things have been progressing. The biggest difficulty, though, has been for some defendants who, particularly those with learning differences, in attending, first of all, and following proceedings. It's often far better, far more immediate if they're in court, so they can pick up on body language rather than just somebody's image on the television or their voice on a telephone. We've noticed a real difficulty for some people in actively participating in hearings. The biggest difficulty, though, for crime has been in relation to juries. We've only been able to use remote hearings in a very limited way for trials. We've had several multi-handed trials at Nottingham that have taken place where we've used multiple courts, simply because we can't get everybody into one court socially distanced. So we've had the leaders in one court with the judge and the jury. We've linked into another court where the junior counsel are with some of the other defendants on bail. And sometimes we've even had a third court available that other people can link into remotely to watch proceedings. I don't see that's going to change. I think the idea that we're going to be able to have trials where juries are entirely remote in a different location doesn't immediately grip any of us who practice in crime as being a good idea. The idea that the people who are responsible for making important decisions are somewhere else and that you can't see them and pick up easily on their body language and keep an eye on them all the time to make sure that they are participating, they are paying attention, is something that I think is probably a step too far, but we'll see how that goes. So far as some of the questions that have been submitted in advance, can I give 4 top tips, or tips as they're called, for those who are appearing or hoping to appear in court in crime in the near future? The first is, please remember that you're appearing in court. Some of the things that we've seen in the last year make people wince. They include people sprawling on a sofa or sitting on the edge of an unmade bed whilst appearing as advocates in the Crown Court. They include people who've forgotten and start vaping in the middle of a hearing, people who are drinking on a big old mug of tea during a hearing, and people who haven't thought about the fact that not only can we hear them, but we can see them as well. And it might be a good idea to dress as if you're going to court. I don't mean wigs and gowns, but we had a very unfortunate incident where somebody had put a suit and tie on the top half and hadn't appreciated that behind them, where they were sitting at the desk, was a mirror, and we could see that they were wearing shorts and slippers. I didn't mind. It was a bit distracting for everybody else, and nobody could quite work out exactly why it was that people weren't listening to what they were saying. Second top tip is, please remember that if you are attending a court hearing in crime, you are inviting everybody else on the hearing into your house. Please think about what's behind you on your screen. Try and make it as neutral as possible. We don't care where you are, whether you're sat on the stairs, whether you're in a bedroom, kitchen, lounge, doesn't make any difference. But if you don't want people to see what's behind you, please move it. You've got an extensive Nazi book collection. You've got all 3 books in the 50 Shades of Grey trilogy. Good idea to move them before you start, because people will be watching. Similarly, if you've got pictures of your children behind you, lovely to see. I always like seeing inside people's houses, but bear in mind the type of people or some of the defendants that will be part of the hearing and some of the offences that we'll be dealing with, and consider whether that's appropriate. That extends to tip number 3. If you're defending, please try and remind any defendants you're representing on bail that they're appearing in court and they need to behave appropriately. The case that one of my colleagues dealt with 2 or 3 months ago of a man charged with dangerous driving, he thought it would be a good idea to link into the hearing via FaceTime whilst he was driving. Didn't go down particularly well and didn't do much good for his chances at trial. Similarly, the man charged with sex offences who appeared via his laptop, sat on the end of his bed where some of the offences were said to have taken place. Not a good idea. We've had a man who decided to attend wearing absolutely nothing on his top. He thought that was appropriate. And we've also had somebody leave one of the hearings without saying anything in the middle, And when he came back explaining that he had to go and take in an Amazon parcel from the front door and he was very sorry. So if you get a chance to remind defendants that they are effectively appearing in court, that's always a good idea. Finally, the most important tip is if you are practicing in crime using remote attendance, don't worry. We all appreciate now the difficulties in joining, dropping out when the signal isn't particularly good, trying to talk when you don't realise you're on mute. Don't worry about it. We had £1 for every time somebody had to remind people that they're on mute and they can't be heard. None of us would be doing this job anymore. Please don't feel anxious. Pets, children, washing machine kicking into spin cycle behind you in the kitchen. We've seen it all over the last year. As long as you do your best to try and minimise as much as possible, the important thing is that you are hopefully at some point able to join and take part. Well, so far as the future is concerned, nobody really knows what's going to happen any more than we really had any appreciation a year ago about what we'd be doing now. No doubt with the relaxation of lockdown, we'll see more people physically appearing in court. As time has gone on over the last year, we've had more people physically in court. We've done our best to minimise footfall by making as much as possible remote, but some cases people just have to attend. No doubt that will increase when it's safe to do so. But it seems to me that the benefits that we've got from using remote hearings for some of those short hearings, bail applications, custody time note applications, mentions when the defendant isn't present or when the defendant's in custody, the kind of cases where historically people have either driven or caught the train for over several hours to get to a hearing, taken 5 minutes to do the hearing before taking several hours to get home, and probably spending more on travel than they actually got paid for the hearing, I hope have gone. I hope very much that as we go forward, those short cases can still be remote because it makes things easier for everybody else. I haven't got any particularly embarrassing stories. I've got an embarrassing story about one of the very junior barristers who attended a hearing several months ago. She had all of the difficulties that we're well familiar with trying to join in. She tried and kept bouncing off the CVP system. So her name would pop up, a screen would pop up, and then she'd disappear. And that went on for 10 or 15 minutes. It was accompanied by a flurry of messages on the system and emails to the court, getting more and more anxious, more and more upset and worried about keeping everybody waiting and apologising profusely. When she finally managed to get on the system, she looked fairly dishevelled, fairly flushed and fairly fraught by the whole business. She launched into a huge apology for keeping us waiting. I told her not to worry, we'd all been there, it didn't matter at all. And just as she thought there was light at the end of the tunnel because she was now there and everybody was happy and there was nothing more to apologise for, the washing machine in the kitchen behind went onto full spin and she slumped. It happens to everybody. I hope most judges these days are fairly tolerant about all the difficulties that we all are well familiar with, whether you're talking in court or whether you're zooming into other people in your family. I hope that's the position. It is usually in my court. I hope it's the position in other people's court as well. But there we are. That's all I want to say.
John.
Thank you, Barry. Good evening, everybody. My name's John Livesey. I'm an employment judge sitting in Bristol. The Southwest region centred in Bristol extends from the western suburbs of Brighton down to Land's End and up as far as Gloucester. We're a large region, but we certainly don't handle anything like the caseload that some of the other regions handles. What I'm going to give you, because I know you're a very broad range of attendee on this call, from students up to very experienced members of the bar. I've got some very practical tips, which I suspect will be very simple and well known to some of you, but I think it's important that we get those across, in particular to the more junior members. I've got also a little bit more insight into the way that the tech is going to look in the future. So I'll start by sharing that with you and tell you a little bit more about CVP and VHS. CVP, as you probably already know, is the certainly preferred platform that HMCTS are using at the moment. We in the tribunal, certainly in Bristol, haven't used Teams or Skype or Zoom at all. We've been on CVP from the very start. And we've been one of the areas which has been prepared to pilot the new model, which is known as VHS. Let me tell you a bit more about the history. CVP is a commercial product manufactured and supplied by Kinley, for whom HMCTS pay a fee. I think we pay a fee per courtroom that we use. And that's expensive. And so as far as we could tell, a few folk in the back of a shed somewhere near Stoke-on-Trent decided that they would try and mimic CVP by producing something that we were initially told was called CVP Plus. In fact, it's called VHS. We nicknamed it CVP Minus, but it is getting a lot better. VHS stands for Video Hearing Service. And it does exactly what I said. It does mimic CVP in the way that it runs. It gives you a virtual courtroom. And importantly for the tribunal, it gives us the ability to talk to our members. If we're sitting on discrimination claims, I sit with 2 members, and it gives us the ability to interact with them in separate rooms, just as you can have breakout rooms in CVP. There are disadvantages with it, and they're quite significant at the moment, but they are being addressed. They're very alive to the problems, but they're not on top of them yet. And they thought they were on top of them sufficiently to announce that they were going to roll VHS out to the entirety of the civil court building in Birmingham. Now, anyone that knows the kind of work that's done in that Bull Street court building every day would be astonished to think that they could simply switch off CVP and turn to VHS overnight. That wasn't going to happen. And I don't think it has happened or will happen immediately. There is still some way to go. For example, unlike CVP, you can't screen share on VHS. Unlike CVP, as far as I'm aware, you can't access VHS on a smartphone. The real difference for us is in Bristol, we have a hub of HMCTS staff who are running the CVP hearings physically co-located in the building. And quite often, if technical issues become very difficult indeed, I can go and speak to the CVP clerk and work out precisely what to do, what the problems are, in a way that I can't do as easily in the chat. Now, the VHO, the video hearings officer on VHS, is not contactable in any chat. There is no chat. And unfortunately, the telephone numbers that they give us for the VHOs are not direct lines to the VHOs, it's to a call desk. And so the problems that we encounter are not surmountable immediately. And that is frustrating and problematic. But as they say in Apollo 13, we've never lost a man in space. We've never lost a hearing yet. We've never lost a video hearing, whether it's VHS or CVP. There are ways of overcoming it. And of course, if for VHS hearing has failed, we've been able to say to the VHOs, largely based somewhere in the Potteries in the Midlands, that we're simply converting it to a CVP hearing run out of Bristol, and one of our obliging clerks will be able to send out links to the parties and will launch it as a CVP hearing literally in 5 minutes. And of course, if all else fails, then there is Teams, the Skype, the Zoom, but we haven't yet had to resort to that. So be aware that VHS is likely to be the future. I'm sure it is going to be improved. There are I don't think there are bandwidth issues in the way that there were bandwidth issues with CVP initially, but clearly it is in HMCTS interest to not have to pay Kinley on a long-term basis. So be prepared to see VHS being the preferred platform at some time in the future. Just a little bit, perhaps more basic words about tech generally. For those of you that don't know, if you're using VHS or CVP, your preferred browser is Chrome or Mozilla. It doesn't work well, sometimes, if at all, in Explorer. Please remember also that quite often when you start a computer, Teams in particular, if you've got Teams on your computer, will launch in the background. You can close it by clicking the little cross in the top right corner, but Teams is stubborn. It won't disappear completely. And quite often the problems that we have, particularly on CVP, it's the same on VHS, is a camera problem related to the fact that Teams has grabbed the camera and won't let any other programs use it. So you've got to press Control-Alt-Delete. You've got to bring up the little program run by the computer, which enables you to properly close Teams down. And then hopefully that will release your camera to be used by whatever platform you're using, whether it's VHS or CVP. Echo what everyone else has said in terms of two screens. Particularly, obviously, for the purposes of running the hearing and running your bundle. And also the other thing to remember, by all means, have your mobile phone handy if you are using it as a second means of communication with your lay client or solicitor, witness, whatever it may be. Don't put it right next to your PC, because that certainly can cause interference with CVP, if not VHS. Now in Bristol, certainly, and I'm sure this is being rolled out nationally, we've got a couple of new innovations in our physical courtrooms, which are called JVS screens and all-in-one screens, which have enabled a lot of the hearings to take place in a hybrid way much more effectively. So the JVS screens are the big mobile screens that you'll see on the side walls of court, or maybe mobile, which enable very effective CVP links to be generated, multi-user, very good cameras, excellent microphones. The all-in-one screens are effectively computers built into a screen, which can be used by litigants in person mainly. So if they are in the court room, and if others are joining remotely, typically, let's say it's a hybrid hearing where you've got one party remote, one party physically there, they will have the CVP hearing in front of them, but they can also speak to the screen in the same way that I'm speaking to you, and the distant party will be able to communicate. Very good bits of kit, which if you haven't got them or seen them, you will, I'm sure, see and have in due course. Obviously echo everything that's been said about quiet rooms. I have been in our court building every day since 23rd of March last year, so you will appreciate, perhaps having watched what I've been doing over the course of the last hour, that I'm fairly inexperienced working from home. I haven't blanked out my screen. I've got a dog that insists on coming in and going out. I didn't do what leading counsel did to me the other day, which was to completely disappear behind a wall of fur as his cat walked across the camera. He didn't realize that the cat had wriggled its way into the room. But the best one was Mr. Peacock, who was a litigant in person the other day. And every time either counsel on the other side or I said his name, his dog let out a single bark. It was brilliant. Mr. Peacock, woof! Mr. Peacock, woof! It was superb. And that for me took the biscuit. We were all in hysterics. We did have a poor client the other day who his central heating had broken, and not broken in the usual way where it was off. It was on permanently, and he was rather hot, and he'd had to open all his windows. And with the first blush of spring, the dicky birds in South Wales, which is where he was joining us from, were extremely noisy. So we had to make him shut his windows because we couldn't hear him above the various forms of ornithology outside his window. I do echo really strongly what Stephen has said about remembering that you're in a courtroom. Every day I do a hearing, because we're in the Civil Justice Centre in Bristol, I physically go into court. I physically have a coat of arms behind me. I think it makes a difference. I think the extent to which we can impose higher levels of solemnity into these hearings is really important, because if they don't care, that they're drinking coffee or that they're lying recumbent on a sofa. The question that we're asking ourselves as judges at the back of our minds is, do they really care that the evidence they're going to give is right? And that's what most concerns me about any remote hearings. Will the evidence that this person is giving be the same evidence if they were giving it in front of the person that they say is their tormentor or they're accusing themselves? It is a concern. One other very small practical tip in relation to your appearance as counsel is in relation to the bundles. Because I'm sitting with members, I'm quite often having the members come into the court hearing with me so that we can be a full physical panel of 3. If it's a hybrid hearing, then obviously that will happen. If not, then even if both parties are remote, it enables us to have our chats more easily. We do not have 6 screens, and one of the clerks will have pressed print on the bundle. The difficulty then is if some are working from a hard bundle and some are working from a PDF, typically PDF Exchange is what we're using, the numbers don't match. And so quite often when counsel says, please can the witness turn to page 422, it might be 428 or it might be 450 in a physical bundle. And having the 2 match is a real benefit. And so a simple tip, please try and get your index to be paginated with the rest of your bundle, because that's obviously the way that the PDF works. Real difficulty, and it does make a big difference if you can master this, and I'm not doing it, is look at the white dot at the top of the screen. Because you'd be looking at the judge or the panel or the jury if you were in court. And it's really easy to address any of these video hearings by looking at the people that you're addressing, but they're not at the camera, they're below. And doing that, I know, is difficult and it feels very alien, but if you can get into the habit of doing it, I do think it really helps. Finally, the future. Well, we had a document from our president today or yesterday telling us what our roadmap looked like. And it looks like this. We are back in physical hearings for all multi-day hearings by default. Multi-day hearings, of course, are our big discrimination claims. Anything more than 2 or 3 days are likely to be by default in person. But that is the default position. And of course, it's always up to the judge or panel to decide whether that should in fact be the case. There will be cases which will still warrant remote hearings in multi-day work. Insofar as non-multi-day work is concerned, we used to do all of our case management by telephone. That will continue. I suspect the only difference really to the way that we're looking going forward is that the much shorter hearings will by default be likely to be by video. Now, the huge benefit, of course, you've heard it from others, is that with this technology, we have effectively tripled our estate, our physical estate. And we have, surprise, surprise, in the Employment Tribunal, got the largest backlog that we've ever had since our creation, I think in the 50s or 60s. Employment and the loss of it has been, of course, a very big casualty as a result of the pandemic. So that's what our roadmap looks like. Our president has said that it's likely to be around 2 years, and it will certainly be different for other parts of the country. I know, for example, that in London, it will be different because they have buildings which are unusable in the same way that our building is usable. So don't take what I say to apply nationally, but things are changing, and certainly there will be a role for video hearings in the future, but it's not regarded certainly by him and I think by most of us as the way forward on a permanent basis for the lion's share of the heavy work. Barry, that's all I've got to say. Thank you very much.
Okay, thank you very much to Joe and Christine and Stephen for that. picking up some of the issues that have been raised in the chat, and please, anyone do join in with that. Matters that I can cover in relation to direct access and difficulties caused by that. I think that that's a very real issue in terms of communication, which would factor into whether or not you can properly do a hearing remotely or not. And it's going to be very difficult in some cases to do it, to conduct the hearing and to be able to have communication with your client effectively if you're direct access. And it may be easier to have those hearings attended. As for the point that John has just made about assistance to litigants, which is a point raised in one of the questions, taking a step back, it was the plan of HMCTS that we have what were going to be called customer service centres, and using the type of phrase much beloved of the civil service. And the idea would be that we'd have these large centres, and there were going to be, I think, up to 9 in the country, which would handle administration and a lot of the backroom, the orders, the backroom work that happened at court buildings. For a variety of reasons, that's not been quite as successful as they had hoped. But it's still the case, as John stated, that as I understand it, and please do correct me, John, if you think I'm wrong about this, that support for litigants who have issues, advocates who have issues, but also for judges during hearings, will not be delivered by physical staff in our buildings, but being delivered remotely. Now, for my part, others may be more optimistic. I view having to actually get somebody remotely by telephone and whenever to help me because my hearing's gone down with a degree of trepidation, sort of akin to trying to get an appointment with my GP, whereby you get 8 o'clock as the start point, and by 8:02, you're number 14 in the queue. And I can imagine there will be a lot of people in the queue for these centres with the amount of calls for assistance with remote hearings up and down the country. I genuinely don't know where that's going in relation to HMCTS thinking. But much as John said, that our estate is effectively increased with the remote hearings, if you look at the pronouncements that were made when the reform programme was rolled out in 2018, the hope is, and the intention is, to reduce our physical estate. So if we can increase the number of remote hearings, then obviously the knock-on effect may well be over the next coming 5 years that there is a reinvigorated court closure programme, particularly relating, I think, to civil and family more than anything, because crime will have such a backlog, and it's the difficulty of holding remote trials, as Stephen said, is still there. But I think for civil and family and tribunals, there will be a pressure on us to use remote hearings because of the advantages that will come through the savings of the estate. That's my understanding. John, do you think it's different in relation to the assistance we're supposed to get, or do you think that's still the plan?
No, I mean, I think that's right. I think the idea is that the VHS, as it's rolled out in its current form, is going to just get bigger, but the VHS officers are still going to be remote. Now, I don't have a difficulty with that as long as the VHO, the officer that's running your hearing, is immediately contactable, because whoever's running your CVP hearing, I mean, it's handy to have them in the building, but as long as they're immediately contactable, it shouldn't matter, frankly, whether they're in the building or distant. But at the moment, we've got this disjunct between the judge or the panel and the VHO. So if we do experience a problem, I can't get an immediate response. I can't get them on the phone. I can't send an email. I don't know what the problem is, why we're not being given their telephone numbers. And, they're aware of the problem, and that will be a sticking point, and it will be a limitation unless it's sorted out.
Okay. All right. Well, look, in terms of any amusing stories, we've not got very many runners in the paddock. I'll share mine, I mean, which I have to say I found really embarrassing at the time, which is that I have had hearings at home as well as in court. I'm from this room, which is blurred, and that's fine. But the window is just there, and that's all right. But I've only got a short space of garden between the window and the road, in which we have our recycling. And I was in the middle of a committal and was sentencing someone when the chap from the recycling banged on the window to complain that we'd not put our plastic in the right part and it was contaminated. And he did so, making sure that he could be heard through the window so that everybody in the hearing could hear me being told off for the fact that our plastic was contaminated and not up to what he thought was the reasonable standard for our recycling. And I have to say that I found really was embarrassing. But it's Barry Searler. Barry was going to share a story with us. Are you prepared to come on?
I am, Barry. It's nice to see you. It's 20 years since we were at the Delphi in Liverpool, if you remember, in that inquiry.
A long time ago.
Long time ago. Can I just make 3 serious points, and I'll tell you my funny story very quickly. I've been sitting as a recorder, essentially in Liverpool and Manchester, and on the National Recorder Pool doing public law family. 3 points. I realised last March that my eyesight isn't very good. So I invested in 2 large monitors bought from Amazon, which connect up to my MacBook Pros. So I can see documents very clearly now, and I don't have to squint. And they're very large, they're in front of me, and they work very well. My experience is very different to John because we were in a different jurisdiction. But I've had in Liverpool the best service you can have from clerks. They've been with me all the time working Microsoft Teams, not the CVP. I can't bear the CVP. You can't see people on it because it's a post stamp, whereas you can see the participants, you can see vulnerable witnesses on the screen with Microsoft Teams. And provided you have a good clerk who has my telephone number, I give him my landline a week before, he has my mobile number, so we can keep the thing going. And my experience, John, is completely different. There's no data protection, there's no issue about giving out telephone numbers. And I think it's absolutely right that you are dog-tired at the end of the day. So I found breaks absolutely invaluable. After 45 minutes, 50 minutes, have a 10-minute break, and so it works. So I'm just sharing my experiences over the last 12 months. They may be the same as others. They may be very, very different. But hats off to the clerk, because without the clerks being there helping you, the system cannot work in finding a fact hearing or a trial, a family trial, where you're deciding whether a child should be adopted or to go into long-term foster care. These are important decisions. I haven't stepped, John, into court since last March. I've been at home, and I've been fortunate enough to make my living working from home. So there it is. The funny story is, just before lockdown, I act as a legal advisor at the General Dental Council, and we had an Italian dentist appearing unrepresented by Skype from Italy. He was facing many allegations of lack of competence. He'd made a mess of many mouths whilst he was working in London. And counsel for the GDC was opening the case around about 10 o'clock, 11 o'clock in Italy. An hour later, we were all watching the screen, watching his reactions to this long opening. And we then saw a large plate of spaghetti appear in front of him. He then started to garnish it. I don't know what he was garnishing it with. And then he started wrapping the spaghetti around his fork in the middle of this hearing. 30 seconds later, he took a call on his mobile phone, whereupon the chair of the disciplinary hearing pulled the plug, and we never saw him again for the rest of the 5 days. That's my story, Barry. I'd love to hear others. Thank you very much. You're on mute, I think. Sorry.
See, there you go. That's my fine. Who hasn't been fined for not being on mute? Has anyone else got a story they want to share with us? Shouldn't be shy. No?
Your Honour, myself, I think I put it up in the comments as well. I was doing a hearing with Ian Roberts here. I was doing a hearing with a public access barrister and his clients when the client's phone went off, and the ringtone was the Borg from Star Trek, and it was literally answer the phone whilst we assimilate you, or something to that effect. I fell about laughing, the judge fell about laughing, the other side fell about laughing even more. I think I could hear someone fall off their seat. However, my barrister, well, out of rage or embarrassment or both, went purple. Not red, purple. That's how much he was holding back. But that in essence is my funny story. Even more now than ever, make sure your phone is either on silent or switched off.
Of course, the difficulty is that many people use the phone as a method of communicating with the client during the hearing, as to how WhatsApp use it as a method to communicate with your client, so leave the phone on. So yeah, people do get interrupted by that. I'm not particularly bothered about, I have to say, people. It's not like it was when I started off, where a number of judges would hit the roof if your phone went off, because you could become offender yourself if you leave your phone on now and again. Has anybody else got any other stories that they would like to share, or is that our rules and riders for the Lincoln's Inn competition?
Well, it's Ian Beebe here. I'm not going to put my camera on, if you don't mind,
No. Because
my study, this isn't really part of the funny story, but last year, just after VE Day, our next door neighbour's house burned to the ground, and our house was slightly damaged. No one hurt, thank goodness. But as a result, having just spent the first part of lockdown clearing my study, all the rubbish in Christendom has reappeared in it. So I'll leave the camera off. But my story actually dates from around 2010, when I was appearing as a solicitor's agent, having been called to the bar and still looking for pupillage. But it's relevant, I believe. I was sent down to a county court in the southeast. I won't name it because I don't really want to embarrass anyone. Before a notoriously ferocious district judge who's since retired. And I don't criticise him at all, for a case management conference in a three-handed PI claim. Fairly straightforward. And I got there, no one was there. And I got in front of the judge and he said, "Oh, good morning, Mr. Beebe, how are you? I see you're on your own." And I was about to say something when the phone rang, and counsel for one party from Liverpool and counsel for another party from Birmingham called in on the phone, because they believed it was a telephone hearing. And the judge, who was fairly famous for his facial expressions, stuck his eyes out on stalks and told them in no uncertain terms that this was not a telephone hearing, it was an in-person hearing, it's never been a telephone hearing. And some concession to them, he said, "If you can turn up into court in the next 5 minutes, I'll hear you. Otherwise, Mr. Beebe can have whatever order he wishes." Which I have to say, I found quite shocking. Luckily, my instructions were fairly uncontroversial, and it proceeded fairly straightforwardly in the next 2 minutes after the 5 minutes had expired. But every time I've seen notice of hearing since then, I've double checked it to make sure I know, particularly if it's the notice of hearing says telephone hearing, I phone the solicitor and say, "Are you sure it's a telephone hearing?" Because I really don't want to be in their position.
Well, we've got the reverse in terms of one aspect, in terms of hearings where people turn up and the judge isn't there. So we certainly have that, where the judge has assumed it's remote, it's been attended, everyone's turned up, and then you're madly trying to patch a judge into a hearing somehow. And that's incredibly difficult when everyone else is in the courtroom and you're appearing by a star phone from somewhere else. Okay. Anyone else got anything to add in relation
Yes, I have, Barry.
to
This is from 30 years ago and just shows how things don't change. The mad judge, of course none now, called Jack Ellison. He was known as Mad Jack, and it was well known to people who appeared in his court that he kept a bucket full of water. And if a phone went off, he would insist on having the phone and he put it in the bucket. So that's, of course, a complete change from the approach that the judiciary have these days, of course. I understand.
Yeah, well, I think now you'd get a bill, wouldn't you? But I mean, it's like the language has changed. You don't even talk about telephones anymore, do you? It's all about mobile or landlines or various different other things.
Absolutely. It just brought it back.
No, I think there's a few of us probably here of a sufficient vintage where if you think what we have now, prepared to what they would cope with or prepared to countenance in the sort of 1980s, I think you would have had people whose blood pressure would have gone through the roof.
Absolutely.
But all right, has anyone else got anything else to share, or should we go to our breakout rooms?
Barry, it's Peter Fields here. Just one anecdote is that I was defending a defendant who was charged with exposure, and it was a fitness to plead issue, and he was in a care environment, and perhaps to make his point, unwittingly he got up, walked towards the camera and started to unzip his trousers. To my horror, he was actually unfit to plead, and there were 3 experts who testified to this effect, but it was quite difficult because the court clerk, actually nobody knew what to do. And very quickly, the people in the care environment ushered him away from the camera, which fortunately was turned off. But it was quite alarming as to see that happen, given the nature of the charge. But it did prove he was, in fact, unfit to plead.
Okay, this is one thing, and I can't find the link for it, but somebody on the Northeastern Circuit, I don't know for did a song. It's using the music from Baldoonican's Delaney's Donkey, called The Day They Tried a Hearing on the CVP. And if you get a link to that, it's really good. He's very talented about, pushing it and shoving it and hitting it and swearing at it, and nothing ever happens. Okay, well, we're now, I think, at about 7, so it should be the case that we've got breakout room